Hi, everyone. Welcome. My name is Carrie Molkowski. I am the Director of Education here at FAIR, and I am delighted to be your moderator for today's discussion. So before we get started, I just wanted to go over a few quick things. First, just to let everyone know, this session is being recorded. So if you miss something, no problem. You're going to get an email from FAIR that will give you access to the recording, I'd say within a week. And then also we'll post the link on FAIR's website. So you'll definitely get to check this out at a later date. So in lieu of recording, everyone joining us today is going to be muted to make sure that we can get a quality recording. But this definitely won't stop you from, joining in on the discussion. Everyone should see in a Zoom toolbar, it's black and should be at the bottom of your screen. You'll see like a little Q&A button, and you can use this to communicate directly with me or any other FAIR staff that we have on the call. Please let us know if you're having any kind of technical difficulties, and we'll definitely do our best to help you out. But you can also use this feature to ask questions. We've built in a little bit of time at the end of the discussion for a few moderated questions. But just to let everyone know, we do have a full deck today to cover, so we want to make sure that our presenter can get through all of his presentation. So we may only be able to take one or two questions at the end. So with all of that said, without further ado, it's my pleasure to introduce today's presenter, Jim Long. After graduating from the University of Texas School of Law and clerking for a court of civil appeals in Texas, Jim Long served for 23 years as a judge advocate general officer in the United States Army. He is a former senior attorney with the Office for Civil Rights, U.S. Department of Education in the Denver Regional Office. He is currently a member of the board of directors of the National Association of ADA Coordinators and is the principal in educational rights consulting, providing a broad range of consulting services to school districts, colleges and universities, and parents on a spectrum of civil rights issues. Jim is a senior consultant with Employment Matters LLC Flynn Investigation Group. He serves on the board of directors of the Zen Center of Denver. Jim and his wife, Nancy, have 4 children and 3 extraordinary grandchildren. At this time, it is my pleasure to turn the presentation over to Jim to get things started.
Thank you very much, Carrie. Before we start, I want to take a brief moment, because I think it's so appropriate with our topic for today, to remember Justice Ruth Bader Ginsburg, who begins lying at rest at the Supreme Court today, and will be honored today, tomorrow, and Friday as she lies in state at the U.S. Capitol building. She spent a remarkable career fighting for equality for all in this country, and that's really what this presentation is about today. I'm going to be talking about Section 504 of the Rehabilitation Act of 1973, the Americans with Disabilities Act of 1990 as it was amended in 2008, and focusing on the protection of K through 12 students who have allergies severe enough to be considered disabilities. And I'll talk about what constitutes a disability and the details of ensuring the protection of these students. Again, this is a significant issue of equality in our country under the law, and it's important for parents, particularly of students in K through 12 education, to understand what their rights are and what the rights of their students are. These materials are provided for informational purposes only and not to be construed as legal advice. If you need legal advice, you should consult your counsel. There is not permission for reproduction and publication and duplication of these materials, partly because some of them have been donated by my colleagues who are happy to share them but not have them reproduced. I'm going to first talk about the requirements of Section 504 of the Rehabilitation Act of 1973 that deals with students with disabilities in education, and Title II of the Americans with Disabilities Act. We'll also talk about explaining the responsibilities of public schools in educating students with disabilities. Well, first, let's talk about which schools are covered by Section 504 and the Americans with Disabilities Act, Titles 2 and 3. Section 504 applies to all schools that are receiving federal financial assistance. That financial assistance goes to all public schools, and it's funneled through the state education agencies to those public school districts. And when I talk about public schools, I'm also talking about charter schools, because charter schools are public schools, even though they operate mostly independently from school districts, although they are chartered by either a school district or a state chartering agency. But nevertheless, they are public schools because they receive federal financial assistance. Title II of the Americans with Disabilities Act applies to public entities. All those state, city, county, and local government agencies and entities that serve the public, including public schools and public charter schools. Title III of the Americans with Disabilities Act applies to places of public accommodation. Those are hotels, restaurants, camps, and private schools. Even though they are considered private, they nevertheless are subject to some of the provisions of Title III, and I may talk briefly about the differences between their obligations and the more broader obligations I'll be focusing on today. But it's important to remember that Section 504 does not apply to private schools. The IDEA is something you may have heard about, the Individuals with Disabilities in Education Act. It is different from Section 504 and the ADA because it applies to a particular set of disabilities and not all students with disabilities. And it defines disability differently. To be protected under the IDEA, a child must have a particular listed disability and needs special education and related aids and services. Under Section 504, a qualified student with a disability is protected regardless of whether the student needs special education. And normally with special education, we're talking about some mental impairment that requires special education services. Okay, so what do I think you need to know, and what do school districts need to know? And these are things that you can share with your school district. If you're having a disagreement with a school district about what your student needs, one of the things I encourage you to do is talk to them about Section 504 and the requirements of Section 504, and if necessary, get together to contact your local or your servicing Office of Civil Rights office, and I'll talk about how you find that a little bit later. To begin with, school districts have the responsibility of locating and identifying students in their districts who have a disability. They must identify and locate students with disabilities who are not receiving a public education and notify the parents or guardians of those children with their rights under Section 504. And their obligation is to provide a free appropriate public education that we call a FAPE. That's free appropriate education to each qualified student with a disability, any student within the school's jurisdiction, regardless of the nature or severity of the disability. But this is different from the IDEA's FAPE. That FAPE focuses more on making academic progress. Academic progress is not a key element of understanding FAPE under Section 504. Now, I realize I'm moving kind of quickly, but we have a lot to cover, and this is sort of background material that I think most of you will be familiar with. The IDEA's disability categories that a student must fall under for services under the IDEA are listed on this slide. You can go back and look at that. But I'm going to move on and talk about free appropriate public education under Section 504. First of all, it means free. That means not charging costs related to disability services for students, but they may charge usual fees paid by all students. For example, students in high school who are taking AP courses typically are required to pay for their books. If that's true of all students in AP courses in high school, students with disabilities may be charged for those books too. But they may not be charged more than others if they require textbooks in a particular format. And appropriate means regular or special education and related aids and services designed to meet a student's individual needs as adequately as needs of non-disabled students are met, and that's equal opportunity. And so the general thrust of Section 504 is to ensure a level playing field for all students with disabilities. There's a three-part process that Section 504 requires. First, involving the identification of students with disabilities, then evaluating them, and finding a placement for them. And I'll talk about evaluation and placement as we go on. Districts must individually evaluate any child who, because of a disability, needs or is believed to need special education or related aids and services. And remember, I said earlier that the district is responsible for identifying those students within the district's jurisdiction. Now, some kinds of disabilities, particularly severe allergies, are in some ways hidden disabilities because they're not obvious to the observer. So parents will need to help the school district identify their student if they believe the student has a disability and as a result needs or is believed to need special education or related aids and services. And those aids and services may be very expansive if we're talking about a student with severe allergies. For example, it could be services related to having in stock and having people available to use EpiPens. It may have to do with what services are going to be provided on school trips, during athletic events, during other kinds of events and activities. So related aids and services is a rather broad term, and we can talk about that more as I go along. When must the evaluation occur? Before a student is placed. And a placement is those aids and services that a student needs. The purpose of the evaluation is intended to answer two particular questions. First, does the child have a disability under Section 504 in Title II? And they both have the same definition of disability. And if so, what are the child's individual educational needs? All right, does the student have a physical or mental impairment which substantially limits one or more major life activities? And these are the three critical elements of the definition. An impairment is any physiological condition that affects a bodily system or any mental or psychological disorder. Then we ask, does the student's impairment substantially limit one or more major life activities? And with respect to some kinds of disabilities like allergies, it means when the condition or the impairment is active, and it doesn't have to be active all the time. In 2008, Congress passed the ADA Amendments Act that established that even disabilities that are transient or episodic, like some kinds of diabetic problems, some kinds of asthma, allergies, and similar kinds of impairments, even though they're not active all the time, they are still to be considered disabilities if they substantially limit one or more major life activities when they are active. These are some of the major life activities, and I've highlighted some of them as related to disabilities associated with severe allergies, like speaking, breathing, eating, communicating, and concentrating, thinking. Those are all major life activities. So we ask, does the impairment limit or affect one of those major life activities? Major life activities also include major bodily functions and the operations of major bodily systems. So functions of the immune system, the respiratory system, and other bodily systems, the circulatory system. If they are affected or the impairment affects those bodily systems, they can be considered as disabilities. And the substantial limitation does not mean severe restriction or inability in performing a major life activity. It doesn't have to rise to that level. And in determining substantiality, we look to the condition, the manner, and the duration of the impairment when it's active. Okay, so what then do we consider a severe allergy? And I'll talk about a case that that we used to call the Jefferson County rule, we had a meeting with the Jefferson County School District on another subject, and the issue of severe allergies and EpiPens came up. And one of the attorneys for the district asked, does that mean every student in our district who has an EpiPen needs to have a 504 plan? And the answer is probably, because if the student's allergy is serious enough to actually warrant having access to or carrying an EpiPen, the allergy is probably serious enough to be considered a disability. Now, that's just a rule of thumb. We all know that every child's allergy is different. The severity of a child's allergy is different. The episodes of allergic reaction for a single child can be very different. They may become worse and worse over time. They may improve over time. So every child has to be evaluated on their own merits, not related to other children or other allergies or other allergic situations. So the medical information that a parent has, the better it is that they can provide the school district and even provide the district the opportunity to talk to the child's medical provider, the better off we're going to be in determining whether the child's disability or their allergy is serious enough to be considered a disability. Okay, question number 2 then we focus on if we find that the student has an allergy severe enough to be considered a disability, is what are the child's individual education needs? Needs are identified by looking at the evaluation sources, including aptitude and achievement tests, teacher recommendations, physical conditioning, and the physical condition, social and cultural background, and adaptive behavior. But there being active adaptive behavior on the part of a student doesn't negate the fact that the student may have a disability. So for example, a student with ADHD may have learned coping mechanisms, but that ameliorate the effect of the ADHD, but it doesn't mean that the student doesn't have a disability of ADHD. The substantiality of the limitation does not mean, as I said, a severe restriction. The student has to be evaluated, the eligibility has been established, and his or her needs have been identified. Next, let me talk about who makes these decisions about the evaluation and the eligibility. This is done by a team of persons who are knowledgeable about the child, the evaluation data, and the placement options. Those are the 3 key considerations that the team of people considering the student have to be familiar with. Again, they need to be familiar with the evaluation data, the child, and the placement options. So, and this is a topic we'll get to shortly, that means it's probably not the mom and the school nurse. It probably involves others. So next we decide on placement. And placement is not a physical place. Placement is the appropriate educational services designed to meet the student's individual needs. Okay, all of those services that a child may need, or the withholding of some kinds of things. So for example, a student who has a severe allergy may need certain things restricted in a classroom, not provided in a classroom. So no peanuts, no candy used for school projects, things like that may be the kinds of things that need to be withheld in the classroom, not provided, strictly speaking, as a service. And school districts are required to provide the students with disabilities appropriate services designed to meet their individual needs. That means each student must be evaluated on their own merits, not grouped with other students. So it's important when talking to your school district and working out a plan for your student to make sure that the school doesn't stereotype your student. Oh, your student has a peanut allergy. This is what we do for peanut allergies. No, that's not the right answer, really. The right answer is, how does your child's allergy function, and what are the needs of your student? Thus, placement is broader than simply a physical location or setting. And I'll give you an example of how that works. We had a student who was going to a choice high school in his district, and his behavior got a little out of hand, and his ability to attend the choice school was withdrawn, and he had to return to the school that his neighborhood was located in. And his parents complained that he received a change of placement without the normal procedural rights involved in a change of placement, which usually requires a reevaluation. And we pointed out to the parents that the student's placement didn't change, only the physical location of his school changed. His placement, that is the services he was to receive, remained the same. So placement is not a physical place. And who decides? As I mentioned, a team, a group of persons knowledgeable about the student, the meaning of the evaluation data, and the placement options. Now, who is the person or persons most knowledgeable about the student? That's mom or dad or a guardian. Are the parents required to be members of the team? No, but a school district has a hard time explaining why the parents aren't involved because they are most knowledgeable about the student. The meaning of the evaluation data. This may require a health professional, a school nurse, or someone else who can read and understand medical evaluation data probably provided by your medical provider. And the placement options. This is going to require maybe the school nurse, but probably also a school administrator who knows what the school is capable of doing and how it goes about doing it, so that when a 504 plan is written, that individual will be able to clearly articulate in the plan how the school is going to go about providing the services required in order to provide the student a FAPE. The team carefully considers evaluation information from a variety of sources, including the parents and providers and histories of episodes if the student has an allergy, and all the significant factors affecting the student's ability to receive a free appropriate public education. The team then documents all the information considered. This is important for when there are differences of understanding down the road, to make sure we know what the team considered and how it went about making its decision, to ensure that it does not rely on assumptions regarding persons or disabilities or classes of disabilities. Focusing on the facts, ma'am, just the facts. And again, it's about an individual determination for each student. Types of academic settings in which services may be provided are regular classes with supplementary services, or special education classes, pull-out services. Now, this isn't typically going to apply to students with allergies as disabilities. It may more regularly apply to students with more learning disabilities, but there are students who have severe allergies who have other disabilities too. And all of their disabilities must be considered in determining what an appropriate placement is for them. All students must be educated, pardon me, with non-disabled students to the maximum extent possible. In the early years of Section 504, we found that some schools were isolating students with disabilities and committing an offense that we called warehousing of students with disabilities. Placement should be in a regular classroom unless an appropriate education cannot be provided there. And why is this important? Consider a class party. Let's say there's going to be a birthday party in the classroom, and I'm sure all of you know enough to know that there are problems with some of the food-centered activities in our schools, and how they're not only often bad for students with severe food allergies, they're bad for a lot of students for a lot of different reasons. But let's say there's going to be a class party, and a student with a severe allergy to, let's say, peanuts and dairy products is in the classroom. And the school district's answer to that student and that student's disability is to say, okay, well, while the party is going on, because there's going to be cake and ice cream, which you can't eat, we'll let you go to an empty classroom and have a popsicle. That's not equal. Separate is not equal in that sense. And so we would require the school district to provide services that ensure the student will be protected in their classroom, where they get to participate with non-disabled students to the maximum extent appropriate to the needs of that student. And if that means we're not going to have cake and ice cream for a party, we're going to have something else, then that's what it means. And all of this needs to be thought through in advance and included in the placement document, the 504 plan. Okay, once the placement has been decided, then we implement the plan. Well, what plan? What is it and where is it? Interestingly enough, Section 504 does not require that the plan be in writing. However, I don't understand any way a school district can have a plan and follow the plan and have everybody who needs to know the content of a plan if it's not in writing. So we always recommend that the school district provide 504 plans in writing. Most of them have form programs on their computer so that they can quickly and easily generate a written 504 plan, so that mom and dad or guardians can have a copy, the necessary members of their team can have a copy. And where is it? It needs to be somewhere where everybody who has responsibilities under the plan can see and follow the plan. It's especially important that substitute teachers know where the plans are so that they can review the plans for students in their classes. Because we find a number of times requirements of plans get skipped because nobody bothered to inform the substitute teacher who was coming into a classroom. Now I want to talk briefly about an IHP, an individualized health plan, often prepared a school nurse or a health professional with a parent or guardian without following the Section 504 procedural safeguards that I've outlined. It can be part of an effective and adequate Section 504 plan, but it's not an adequate substitute. For one reason, it's usually developed solely with a school nurse, who may or may not understand other requirements that the school will have to implement in order to provide adequate services for the student. It typically deals only with the symptoms and treatment of a condition, and often then only if the condition becomes active. So for example, an IHP for a student with severe allergies would typically address what's going to happen if the student shows symptoms of a developing allergic reaction or anaphylaxis. But it's not going to explain what happens when the student is going on a field trip. What's going to happen when the student is going with the school debate team to a debate competition? What's going to happen at athletic events? Who's going to be responsible for the school providing someone trained to use the student's EpiPen? And who's going to keep the EpiPen? Where are EpiPens going to be stored? All of these kinds of questions go beyond the knowledge and expertise of the school nurse or other health paraprofessional. And that's why the requirement is for the team deciding the 504 plan to include persons knowledgeable about the child, the evaluation data, which may be the school nurse, and the placement options. That's the key, because it's going to take a school administrator probably to know, what are we going to do in the classroom? What can we do in the classroom? Teacher, what do you have to say about that? What is the coach going to do? Coach, what do you have to say? What's going to happen on field trips? What's going to happen on the school transportation buses, et cetera, et cetera. An IHP simply does not address all of those matters. And that's why I encourage parents to take advantage of their students' rights under Section 504 and not be satisfied with just an IHP. Section 504, that a student be reevaluated periodically, and it just says periodically. And so school districts are responsible for setting up what that period for reevaluation is going to be. Typically, they use the same reevaluation period as they use under the IDEA, which is a 3-year standard, I believe, still. But they can set up a different period. Sometimes it's when a student moves from grade to grade. Sometimes it's going to happen when they move from one school building to a different school in the district, but they must set up those periods. But there's also required to be a reevaluation anytime there's a significant change in placement, not in physical location, but a change in the services being provided to the child. Sometimes school districts, as a child gets older and moves to middle school or high school, the school district wants to alter the services that are going to be provided as part of the placement. Then a reevaluation is required. The school must also ensure that the parents are provided what are called procedural safeguards. That's a system of procedural elements regarding identification, evaluation, and placement of students. They include notice to the parents of their rights, and that should be an annual notice. Typically, that notice is going to be included as part of the 504 plan or the notice of a 504 team meeting. The ability to review the educational records of the student. Understand that the district must allow the parent to review the record, but it doesn't have to provide copies of the record. Typically, school districts will provide parents the right to review the record, and if requested, they can get a copy of the record, sometimes at charge. And due process. Due process is very important in the 504 system. It's the procedure by which a parent can contest the decisions made in a 504 plan or by a 504 team. For example, if the 504 team determines that they don't believe the student has a disability, the parent disagrees, they can go to due process and have a hearing before an impartial hearing officer, who is typically someone from a different school district, with participation by the parent, and the parent is allowed to bring legal counsel or some other advocate to that due process hearing with them. In addition, there must be a review, that is an appeal procedure to appeal, and that's usually an appeal to a state education agency, although there could be some other sort of independent review process provided by the school district. We run into a number of common compliance concerns when we're talking about the provision of a free appropriate public education. And one of those is making decisions unilaterally instead of by a team. Typically in the area of students with severe allergies as disabilities, we found that often there would be unilateral decisions made by a school nurse without a team of persons knowledgeable about the child, the evaluation data, or the placement options, or making decisions that are not based on the evaluation information or the child's needs. For example, making placement decisions based on stereotypical views of a particular kind of disability rather than on the facts associated with the individual child. Most commonly, the problem is failing to implement an IEP. That's the plan developed under the IDEA or a Section 504 plan. And for students who, for example, have severe allergies and are also qualified for services under the IDEA, they would have an IEP, but it would include all of the services they are to receive, even if some of those services would be typical under a 504 plan. So an IEP or a 504 plan requires implementation by the teacher in the classroom, by someone who's providing special services, maybe by the school nurse, maybe by a coach, maybe by someone else. Or not affording parents procedural safeguards, and finally, retaliation. These are common kinds of compliance concerns. Well, the district has some other responsibilities that we need to address, and that has to do with extracurricular and non-academic activities. Students with disabilities must be provided an equal opportunity to participate in transportation, lunch, recess, physical education, clubs, athletics, and other activities at the school. And this may be included in the 504 plan. And if I were a parent, I'd want to make sure it's included in the 504 plan. It answers questions like who's going to have the EpiPen on school trips? Where will food stops be made? For example, if your child is on the high school volleyball team and they're going to an away game and they're going to be stopping for a meal on the way or on the way back, where are they going to stop? And how are they going to make provision for food for the student who has food-related allergies or disabilities? How is that student going to be accommodated? At athletic events, how are the students' needs going to be accommodated? Who's going to have the EpiPen? Who's going to be trained to use it? And I would caution against any school providing that, well, the students in high school, they can use the EpiPen themselves. They may or may not be able to use the EpiPen themselves. Someone else needs to be at least available to use the EpiPen if the student needs to have an EpiPen administered. There are a number of kinds of discrimination under Section 504 in Title II. Denial of FAPE is only one of them. And while I'm mentioning FAPE, I'll point out that under Title II of the Americans with Disabilities Act, which protects these students from discrimination if they have a disability and they're in a public school system. But Title II doesn't provide for a FAPE. The details of FAPE arise under Section 504, and that's why we focus mostly on Section 504 in talking about protections for students in public school. Other kinds of discrimination are different treatment or developing policies that have a different impact on students with disabilities or with particular disabilities. So we can't treat the students differently. That's just standard kinds of discrimination. Disability harassment is a big problem for particularly for students with food allergies, as we've learned. Making fun of a student with a peanut allergy or permitting other students to do so constitutes disability harassment and is prohibited. As soon as harassment is reported to a school, the school must take steps to stop the harassment, to investigate it, and to ensure no harassment takes place in the future, and to remedy the effects of the harassment. And typically what we found was district will, and this is all different kinds of discrimination harassment, but what we find is that school districts will know to stop the harassment, know to take actions to prevent it, but they tend to leave out the remedying the effects of the harassment when taking action to address it. So if your student is the victim of disability harassment because of his or her allergy, or the requirements for providing services to address that allergy and the student's needs, make sure you report the harassment to the school and insist on the harassment being stopped, being prevented for the future, and remedying the effects of the harassment on the student. That may be providing counseling or some other ameliorative action. One of the forms of discrimination that comes up that school districts often don't think about is discrimination by an entity to which the school has provided a significant assistance. This is a key. What about activities sponsored by the PTA or the PTO? And is the PTA or PTO required to comply with the requirements of Section 504 and the Student's 504 plan? Well, it depends on whether the school provides significant assistance to the organization. For example, do they provide the PTA copying services at your school? Is the school PTA or PTO allowed to have email access to the parents of the students? Are they allowed to have free meeting space or free space in a school building at no expense. And each case is determined on the specific facts of that case, but OCR, the Office for Civil Rights that enforces these statutes, is going to look to determine whether the school district provided significant assistance to the organization that then discriminated against a student with severe allergies by not making arrangements, for example, for students with allergies at pajama and movie night being sponsored by the PTA. And the same is true of sports leagues and others to which a school district might provide significant assistance. And also any exclusion, denial of benefit, or other form of discrimination is protected under Section 504. To address these kinds of concerns, the district must publish a non-discrimination notice. It must be available on the school's website and fairly easy to locate. The school district must establish grievance procedures for resolving complaints, and it must provide for prompt and equitable resolution of discrimination complaints. So if you have a complaint about the school's failure, for example, to implement a 504 plan, the district must have a procedure for you to file a complaint or grievance, and it must provide for prompt and equitable resolution of the complaint. The school district must also designate a Section 504 and Title II coordinator to ensure the school district's compliance with Section 504. That person is the individual to whom OCR looks for ensuring compliance and for conducting conducting investigations of complaints. Each of the school district schools is also likely to have an individual responsible for coordinating Section 504 in that building, typically one of the administrators or sometimes one of the special education teachers. But understand with respect to special education teachers, the IDEA is not a civil rights statute. It is a funding statute. It is a mechanism for providing funds to schools to address the needs of students with one of those 13 enumerated disabilities and making sure they get the educational services they need. Section 504 is a civil rights statute. It is not a funding statute. So understand that schools do not receive special funding for implementing Section 504. That means all of the activities, all of the time are taken out of the school's ordinary budget, if you will. And that's why often school districts are reluctant to invest significant resources in a particular 504 plan or in its 504 process. So just understand the difference between the two and why the school is more likely to be able to provide robust services under the IDEA because of that funding. But the Civil Rights Statute, Section 504, does not recognize a difference in the compliance requirements and expects robust compliance. Districts may not intimidate, threaten, coerce, or discriminate against any individual because they have asserted rights under Section 504 or Title II, even if that's a student advocating for themselves, or anyone who has opposed disability discrimination, say by making a complaint, or participated in a complaint process or hearing as a complainant or as a witness. And OCR, the Office for Civil Rights at the Department of Education that enforces this statute takes retaliation very seriously. And I want to discuss briefly two cases. One of them is the Memphis City School District case, which is a compliance review. Now, a compliance review is not a complaint investigation. It is something like a civil rights audit, where the Office for Civil Rights looks at an entire school district with respect to a single civil rights issue under OCR's jurisdiction. So it may look at how the school district is doing in responding to sexual harassment complaints. It may look at how it's serving English language learners, students under Title VI. it may look at how it's doing with its disability services for students. And the Memphis City School District Compliance Review looked at whether it was adequately evaluating students with severe allergies and some other related kinds of disabilities. And it involved 191 schools, and confirmed our understanding of the application of the ADA Amendments Act of 2008. And what I mean by that is our understanding of the application of the ADA Amendments Act has to do with considering impairments that are only episodic as disabilities, because this compliance review looked at allergies, asthma, and diabetes, which were considered episodic, to determine whether the school district was adequately identifying students with those disabilities and serving those students. And was it providing adequate notification to parents of their rights under Section 504? The school district in the resolution agreement was required to provide a more robust notification to parents than it was providing. It was required to revise its policies and procedures specifically addressing allergies, asthma, and diabetes. It was required to form teams to review records of all students with health concerns. So they basically had to do a review of all the students who had health concerns to determine, do they need to be evaluated and do they need a placement under Section 504? And notwithstanding any IHP, teams will determine whether students should have a 504 plan, underscoring the point I tried to make earlier that an IHP is not sufficient for a student who has a disability. It also required training for the superintendent, the directors at the school district, principals, assistant principals, school counselors, nurses, and other staff, including teachers, involved in the referral, identification, evaluation, and placement of students under Section 504 and Title II. In other words, widespread training for the whole school district because it was failing to address the needs of students with allergies, asthma, and diabetes. If parents do not have pertinent documentation, the district would obtain the needed medical information at no cost to the parent. So one of the things that I failed to mention earlier was in the evaluation of students, if the district needs some kind of medical evaluation, it is the district's obligation to pay for that evaluation. Now, the same is not true in post-secondary education, but it is true in K-12 education. Now I want to talk about the Young Shakespeare Players East letter of finding from Department of Justice office, the U.S. Attorney's Office in one of the states on the East Coast. It determined that this, let me tell you a little bit about the Young Shakespeare Players East. It was a private entity that put on restructured Shakespeare performances for young students so that they could learn to participate in the dramatic activities associated with Shakespeare's plays and be exposed to Shakespeare. And it would be like a ballet school, or some music organization providing musical opportunities for students. It was a private organization providing this unique kind of dramatic opportunity for students. The United States Attorney's Office determined that the Young Shakespeare Players East violated Title III. Remember, Title III applies to private entities that are places of public accommodation by failing to make reasonable modification to its policies, practices, or procedures when such a modification was necessary for students with disabilities, and by retaliating against the parents who advocated on behalf of those students. The primary student involved had life-threatening allergies and had experienced anaphylaxis. The mom wanted a nut feed program and an adult trained to use an EpiPen. Now remember, since we're talking about Title III, Section 504 doesn't apply, but this gives you a flavor for how the American with Disabilities Act will step in when Section 504 would not be triggered. They had conversations with the parents that dragged on for months. The director threatened to shut down the whole program rather than comply with the advice that had been given it by its own attorneys to accommodate the student. The director ultimately required the parent to take full responsibility for the child's participation. And I am sure that there are parents out there today listening whose school district said, yes, we'll provide some services to your student if you provide them, like you provide the lunches at school, even though the school provides lunches for other students, which of course is not acceptable. The United States Attorney's Office found that the youth's allergies did constitute a disability and that accommodations were not unduly burdensome, and that the young Shakespeare programmist had retaliated, and on and on and on. So it required the YSPE to provide remedies, which included revised and prepared policies and money damages to the youth and the parents, and to comply in providing the accommodations requested by the parents for the student. And so this illustrates ways in which just beyond the walls of the school district, you may have basis for advocating for the rights of your student. And what's the result? The result is going to be an equal opportunity for all students. And that's what we're after, equal opportunity, because without it, there's no justice for anyone. For further assistance, you can contact your regional OCR office. There are 12 OCR offices around the country. Each office has a responsibility for particular states or territories, and they can provide answers to your questions and technical assistance. They can receive and investigate your complaints. They can, sometimes they'll be willing to talk to you in the school district to clarify an issue or a topic of OCR guidance. But ultimately, they're responsible for enforcing Section 504 and Title II in public schools. There's information I've provided there, the website, for if you want to find out where your local OCR office is. And you can contact OCR on the internet at www.ed.gov/OCR. Other resources with which all of you should be familiar are the CDC guidelines for elementary and secondary education. They're on the CDC website. They've been there for a number of years. They're very good. They're very helpful. And if your school district is not familiar with them, they should be. There's the specific website or the web page for those resources. And that information is also on FAIR's website. Thank you very much. I hope I've allowed some time for some question, Carrie. Do you?
Yeah, indeed. Thank you, Jim. You have. Thank you so much for that presentation, and thanks for all of our attendees joining. We'll take the next like 7 or so minutes and ask some questions. And first, if I could just have you clarify one thing, because we have some awesome school nurses on the call with us today, and we at FAIR know how strong of advocates they are for these students with food allergies. And you were talking a little bit about making sure that you have a team, and that, you know, a parent and a nurse, you know, they're not the whole team, but they definitely should be part of the team, you know, and they do play a key role. And oftentimes a couple of the attendees commented that, you know, they are kind of the most informed about a student's medical condition, you know, and maybe the only person, you know, on the school campus that has that kind of medical background. So there was a little confusion, and I just wanted to clarify that indeed, you know, school nurses, you know, should be part of the team and are a valuable player in all of this.
I absolutely agree. And I have spent a lot of time particularly in the last few years, making presentations to just school nurses. They are great people. They are very dedicated. They're an invaluable resource to school districts, particularly in talking about students with severe allergies, because they understand it probably better than anyone else in the school building. And they are tireless advocates for students with all kinds of disabilities, but especially for students with these severe allergies, because they know what anaphylaxis looks like and how dangerous it can be. And they can sometimes provide objective and informed and expert uh, advice to school districts on how to address the needs of students with disabilities. So I absolutely agree they should be part of any 504 team dealing with a student with severe allergies, because they are people who are familiar with the evaluation data and interpreting the evaluation data, particularly because school districts most typically do not have doctors available to address that data.
Wonderful. Thank you so much for clarifying. I knew that's how you felt. So moving right on, and this is a question I've received throughout the years here at FAIR. I'm sure you have. And this person was just asking about, you know, what should they do around accommodations that are related to, say, extracurricular activities after school or sports. You know, they were saying, is this something, you know, that is even included in a Section 504 plan? Could it? You know, he said he thinks that the school is doing some accommodations, but they're not documenting it. Is there any advice to kind of navigate those type of after school activities?
Well, I think definitely that the services that are required for the student to receive an equal opportunity should be documented in the 504 plan. Otherwise, how are you going to demonstrate that it's part of the 504 plan and that the district is, or the school is responsible for providing those services? So, for example, with respect to athletics, if a student is going to be participating in athletic events or team events, then I think the plan should, at a minimum, spell out who's got the EpiPen and who's trained to use it. And the school district is responsible for providing that training. What's going to happen if there's a trip? What's going to happen if the school is providing drinks or snacks during those or after those athletic events? For away events or away competitions, is the school going to be stopping for and providing meals or providing the opportunity for students to get meals? And if so, how are they going to address the needs of the student with severe allergies in those stops for food? So part of it requires the parent and the 504 team thinking through what are the extracurricular activities the student is participating in or going to participate in, and ensuring that they've sort of answered all the questions that are raised by the parent and, say, the school nurse, so that all of that is known ahead of time, and that if the student had an allergic reaction, for example, no one's fumbling about trying to find the EpiPen. Everybody knows where it is. The people who need to know where it is, and everybody knows who's trained to use it. And the answer is not mom or dad. It's the school district's responsibility. Now, if mom or dad happen to be there and they happen to have an EpiPen and they are handy, that's fine. But the school district must spell out in the plan how they're going to ensure that this student has, for example, an equal opportunity to participate on the volleyball team. And having the students sit in the bus and bring their own meal for the trip back from the volleyball tournament is not the right answer. Does that sort of answer the question, Carrie?
Very much so. Thank you so much, Jim. We'll hold you just a couple minutes after time, but maybe two more questions. And one's just really general, and you covered it in your presentation. But if you don't mind, could you just talk a little bit about the differences between the IHP and a 504 plan, and kind of just how important it is to have that 504?
Well, as I tried to suggest earlier, an IHP is going to be fairly narrow. It's going to talk about maybe where medications are kept. It may talk about what's going to happen when certain kinds of symptoms show up in the classroom or somewhere else on the school property. But it may not talk about what are the precautions in the classroom. How are we going to control what food comes in or out of the classroom? What are we going to do when there are parties? What are we going to do when there are school-wide events that involve food? And it's certainly unlikely to include what services are going to be provided for extracurricular activities. My experience with IHPs is that they are pretty narrowly tailored to classrooms, and when symptoms occur in the classroom, or allowing a student certain times to go get medication, um, and those kinds of situations. And it may be really great to have them as part of the 504 plan, but they're generally not a substitute for the 504 plan. For one reason, they don't follow the 504 procedures that guarantee certain rights to the parents.
Wonderful, thank you. And just this last question, and it's something that has been on a lot of people's mind, and I know right before everyone went back to school, there was much discussion around, and I think I even read something you were quoted in an Allergic Living article, but it's kind of around COVID and, you know, kids going back to school and perhaps now having to eat lunch in the classroom, and, you know, parents concerned that maybe some of the accommodations that they had set in place won't be honored. Is there anything that you can just talk about, like, around that scenario of just, you know, this coronavirus that we're dealing with and some changes that are happening at school?
Well, I've been very concerned about this myself, because I understand the desire of schools to limit students' exposure to larger and larger number of other students. And so they're confining things to a classroom. One of the things that COVID is calling for is social distancing. And I think one of the things that school districts have to consider is whether that distancing is sufficient to protect the needs of students with severe allergies in the classroom. But if the school district is going to change the placement and change the services required for a student with severe allergies who has a 504 plan, then they must reevaluate the student and reconsider what kind of services are going to have to be provided in order to protect that student in the classroom. Providing a safe, secure environment is not the standard under Section 504. Providing an equal opportunity is. But an equal opportunity means equal safety, equal protection that all the other students are getting. So I think that the parents and the school district are going to have to think through very carefully about what's going to work in the classroom in COVID. I think there are probably solutions, and it may take some creativity to figure them out. While students are supposed to be educated with their non-disabled peers to the extent possible, it may be more reasonable, for example, to take all of the students who have food allergies in the 4th grade and keep them in one small cohort to enable better to serve their needs when they're going to be eating their meals in the classroom. But that may or may not work, and it may or may not be reasonable. But if the school district is going to change the placement of the student, then they're going to have to reevaluate, the team's going to have to meet, and they're going to have to figure out how they are going to meet the needs of the child.
Wonderful, thank you. And I'm gonna hop back on and just give you a proper thank you and just thank all of our attendees for joining us with such thoughtful questions. Again, the presentation was recorded, so we'll make sure to get that out to everyone. And thank you so much, Jim. You provide always the best information. I want to give you opportunity to just say a final piece of advice or a final thought.
My final piece of advice is be patient with the school district. I know that by the time a child with severe allergies reaches 6 years old and is enrolled in school, you parents or you guardians are almost at the end of your rope trying to advocate for your child. But try to be patient with the school districts. A lot of this is, even though the ADA Amendments Act that changed some of this was passed in 2008, school districts and new teachers and new counselors and new school administrators are still trying to get on board with this. So be patient, try to get them educated, try to encourage them to read OCR's materials and the CDC guidelines and become aware of FAPE. And invite OCR to come and teach to your school district, your school nurses, or hire someone like me to come talk to them, to educate them further on their responsibilities and their ability to sensibly serve these children.
Wonderful. Perfect advice. Thank you so much. And thanks, everyone. We'll see you again soon. Bye-bye.
Goodbye.